Okay. Thank you, Mayor. Good evening, everyone. Thank you all for coming. We'll try to make this as painless as possible. We've been through this before, but it's been a couple years, so we like to go through it and make sure everybody knows what they're doing. Most of you are fortunate I'm not there to police your meetings. But I do give the town council a hard time sometimes when they get off topic. So we're going to talk about 4 different things tonight. We're going to talk first about the open meeting law and conflict of interest, public records, and lastly, code of ethics. So let's get started and talk about the open meeting law. If you have questions as we go along, we're pretty informal in this presentation, so feel free to raise your hand and I can address it. So first, the open meeting law. And Arizona is what's called a sunshine state. And we all know that that has everything to do with the weather and nothing to do with open meeting law. But it actually does, because the sun shines on the public's business and the public business is done in public, with a very few exceptions. So mostly in public, we have, it requires proper notice with a posted agenda. And anybody know how far in advance the agenda needs to be posted? Okay, you'll be quizzed on this later, so it's 24 hours. This comes up again, so 24 hours in advance, except for an actual emergency. And a lawful meeting is anytime a quorum of the public body is present. So hopefully every time a public quorum of the public body is present, there will be a posted agenda unless no town business is going to be discussed. So there is an exception where you can have a private discussion in executive session, and they're very limited to specific matters. And those matters are personnel matters, legal advice, litigation, purchase of real property, negotiations with employee organizations, and review of confidential records. So most of those, the reason for conducting the discussion in private is to give the council or the public body an opportunity to discuss, for example, their position in a litigation matter without having to do it in public, because that would kind of defeat the purpose of the discussion, because the other side would know exactly what the town is up to. So that's the reason for it. So if you think that in your head, then you'll be pretty clear on why and what kinds of matters could be discussed in private. Most of the public bodies don't have an executive session. They're mostly for the council, although sometimes the Board of Adjustment might need it. Very rarely, the Planning Commission might have one, but mostly it's the council. So what actually is a meeting? Well, we said it's when a quorum of the public body is present, but also at that time, the public body discusses, proposes, or takes legal action. So you can have a traditional meeting where you have everybody sitting together in a room, or through the miracle of electronics, you can now have electronic meetings. You can have your town attorney on Skype, you could have council members on Skype, or you can have a conference call. Yes?
Well, I was wondering, when you post the agenda 24 hours in advance, of course, the old thing used to be to put it in the newspaper, which nobody reads anymore. How do we post the agenda?
Good question. You post the agenda, and I think that's coming up later, but the way the town posts the agenda is the town has 3 posting sites. Their town hall, the library, and the senior center? Post office. And you also are required now by Arizona law to post it on your website. So all public notices are posted on the website, including the agenda. There are several pitfalls that you can encounter in the open meeting law. Number one is serial meetings. So what's a serial meeting? A serial meeting is when there's less than a quorum of the members of the body present, and they have a discussion about something that's going to come before the board or that is relevant to, it may come before the board or it's before the board at the present. And later, the same discussion is had with more members of the body. So members A, B, and C have this discussion. Member B goes and talks to member C and D, and you've basically had a meeting without public notice and without sitting together in the room without the public present. That's a no-no. So, and the big question here is it enough to constitute a quorum of the body? If it is, then you probably have violated the open meeting law. So the thing to remember here is that a series of gatherings of less than a quorum may constitute a meeting if town business is discussed or proposed. And this includes something like if you're on the planning commission and you're considering, well, maybe, what do you think, Joe, if we proposed an amendment to the UDO to allow, let's see, congregate care homes in a residential district, multifamily residential district. And you have this discussion with 3 people, and then you kind of want to poll the commission and see, well, is it worth bringing to the commission to see if anybody else is interested? Well, if you ask another person, and you've already asked 2 people, and you're a member, you ask another person, you've talked to a quorum, and you've just had a serial meeting. So it's that kind of a thing. The idea seems simple, but technology also complicates things. We used to have to just worry about the phone, but now we have things like email. So you have to be very careful and not use reply to all or forward emails from other members of your body to more members of the public body, because you may inadvertently get into trouble with the open meeting law. So pitfall number 2 is emails. Or emails. So you begin by wanting to send an email. And the first question you ask is, am I proposing legal action? So if the answer is yes, then am I going to send it to 3 or more members of the public body? Because remember, if you send it to 3, then that's 4. So you can only send it to 2. Or if your body is smaller, you have to calculate. I'm talking about here a 7-member body. So if your body is smaller, then you have to use smaller numbers. If the answer is yes, then you can't send that email, because if you do, you have an open meeting law violation. If the answer is no, because you're not sending it to 3 or more members of the public body, then you probably don't have an open meeting law violation. But what if it doesn't propose legal action? Well, the second question you have to ask then is, does it contain facts or opinions that concern something that may come before the public body? And if the answer to that is yes, if the answer to that is no, you probably don't have an open meeting law violation. But if the answer is yes, and this gets a little convoluted, then you go back to, did I send it to 3 or more members of the public body? If yes, then you may have a problem. Questions? That's, I think, our most complicated slide. Pitfall number 3 is social media. So you post comments about the public meeting on your Facebook page. This is your private Facebook page, and you have lots and lots of friends, and you just want to get your opinion out there. Is this a problem for the open meeting law, even if you're friends with the rest of your public body? Well, the answer is not necessarily. So there's a statute that says that you can express your opinion or discuss an issue with the public personally through the media. So if you get interviewed by the television station, or more likely hear the radio, you can talk to them and you can give your opinion, or through technological means, which also means your Facebook page, because it goes out to a greater number than just your public body. So the public sees it. The opinion or discussion is not principally directed at your public body or the other members of your public body, and there's no concerted plan to engage in collective deliberation to take legal action. So you're just putting your opinion out there, and it's generally fine. I will give a caveat to that. If your only Facebook friends are the other members of your public body, then this is not something you want to do. Yes?
If you're expressing your opinion, you need to be clear when you're saying it that this is my opinion, it's not the opinion of the board or the council.
Very good point. And the answer to that is yes. If you are expressing your opinion to the media or on your Facebook page or through other social media means, yes, you need to make it clear that it is your personal opinion, because you do not represent the public body. It's 7 members, and they have to make a decision, and once that decision's made, then that is the opinion. Another pitfall people run into is attending other meetings, and the Attorney General has given some guidance on this one. The Attorney General, every once in a while, gives out opinions on things that he's asked to give opinions on. And it's basically a legal opinion from the Attorney General of the state. It does carry some weight. It is not law. It is not legal precedent. But it is the Attorney General's assessment of how a legal matter, a legal issue, might be decided by a court. Sometimes we disagree with the Attorney General. Most of the time we agree with him. So for what it's worth, his question to answer is anyone making a proposal at the meeting that you're attending of another public body? So say a council member is attending a planning and zoning commission meeting. So if anyone is making a proposal at that meeting that's going to come before the council, which we all know, planning commission recommends to the council, so it's very likely that it's going to come before the council for consideration. If a quorum of the council is present or of your public body is present at this other meeting, then you may have a potential open meeting law problem. So there are, this is our, what do I do? What do I do? So your options are don't attend other public meetings. Sometimes that's doable. If you're interested in an item and it's and the other meeting is videoed, you can watch the video and see what the discussion was. But sometimes you just really want to go. So if you do go, you sit and you listen and you don't make comments and you don't ask questions. Especially if there are more members, a quorum or close to a quorum of your public body at that meeting. Or if all of the council wants to go to the Planning and Zoning Commission, or all of the Planning and Zoning Commission wants to come to the council, and there's something on the agenda that's going to come before the body, notice the meeting as if it's a joint meeting. And then the public will know that both bodies are there. Questions on that? Jamie posts notices of the public meetings. So on the agenda that she posts, it will say a quorum of the Planning and Zoning Commission may be present at this meeting. And sometimes actually Jamie posts notices of events. that will say a quorum of the town council, planning commission, I don't know what the other committees are, redevelopment commission, whatever, may be present, but no town business will be discussed. So like for parades and what, 4th of July
Tonight's
events.
meeting, we noticed
Oh, yeah,
tonight's
tonight's
meeting for
meeting.
all the committees.
Right. So we're sort of discussing town business, but we're not making any decisions. Okay, so the takeaway. Be mindful of informal discussions with other members of your public body. Text messages, emails, and comments made at other public meetings may constitute a serial meeting. But merely reading a media comment from another member or making a media comment is not a meeting. And we show you having fun with your devices. So what do I do to call a meeting? Or what does the town do to call a meeting? Well, there's the question again. You have to post an agenda in the town's official posting places, which we talked about. And how far in advance do you have to post it?
24 hours.
Excellent. You're listening. Except in an actual emergency. Where does this thing go? Oh, if the website is down, can you have a meeting? If it doesn't get posted on the website? Answer is yes. And now we discuss what an actual emergency is. And basically, an actual emergency is not playgroup calling an emergency meeting. It is actually a flood, a natural disaster, fire running through the town, water running through the town, an earthquake, things like that, where, there's public business that needs to be done, but you don't have time to post it. So if there's not flood or fire running through the town, you probably don't have an emergency. Yes?
Who determines that?
The mayor, I believe. Or if the mayor is unable to act, it would be the vice mayor. So now we talk about what must be included on an agenda. You have to, of course, tell people the time, date, and place of the meeting. You have to list what matters are going to be discussed or decided. Or in lieu of that, where the detailed agenda can be obtained. We always list the matters, and we try to give as much detail so that a reasonable person reading the agenda will know whether and to what extent his interests are going to be affected. So that's kind of the guideline that we use when we review an agenda and decide whether or not it's adequate, especially on land use matters. That makes a big difference on land use matters. So there are some optional things that can be on the agenda. One of them is call to the public, which the town does have on their agenda. And at call to the public, the residents or citizens may only address issues, may address the public body on issues that are within the jurisdiction of the public body to act. We kind of get a little loose on that if somebody wants to announce that there's a parade or that so-and-so is holding a fundraising event. Even though it's not something that the council has jurisdiction over, we generally don't object. And this list here is a summary of the state law on this. So the state law does say that the public body may not discuss the matter after the person addresses the council, which is why on your agenda you'll have a response to call to the public on the next agenda, where the mayor will generally respond to questions that have been asked. And if you'll notice, when you get the agenda, or when you look at the agenda, the matters that the mayor is going to respond to are listed so that they're posted on the agenda, and we're not going to get into open meeting law trouble because they weren't posted. The council members or the members of the body may respond to criticism. They may ask staff to review the matter, or they may request the matter be put on the agenda at a future meeting. So the whole purpose of this is that if a citizen comes to call to the public and they're throwing something out there that they would like to see done, I want my street paved and I want a stoplight at the intersection so that I'm not killed when I'm getting out onto 89. The council can't discuss it at that time, but they can say, let's put it on a future agenda so that other people who are interested, other members of the public who are interested in that matter, can come and hear the council discussion. Because if the council discussed and decided it at that first meeting, then the other people wouldn't have a chance to voice their opinions. Other communications that are allowed by state law are reports on current events from the chair, from members, or from a staff person. And on those items, there is no discussion. There might be questions and answers, but there is no discussion of the merits of any of the items that would have to be put on a future agenda. So again, so people could come if they're interested and voice their opinions, or at least listen to the discussion. So hopefully by this point you all know, can we discuss matters not on the agenda? Okay, we have a multiple choice though on this question. Multiple choice answer, A is no, B is seriously no, C, not if we don't want trouble, D is maybe if it's an actual emergency, and E, all of the above. And the answer actually is E. So, but I like no as the answer. Minutes are the official record of the meeting and must include, and this is something that we include in this presentation, although you might think, what do I need to know about minutes for? Well, as a member of your public body, you do approve your minutes. So here's what you need to know. In those minutes, they must say the date, time, and place, who's present, and a description of the matters discussed and what legal action was taken on them, who talked about them, and that's basically it. So when you're reviewing the minutes next time, make sure that all of that is in there before you say yes to the approval. Draft minutes must be available within 3 working days of the meeting. What happens if we violate the open meeting law? Well, any actions taken in violation of the open meeting law are null and void. That's not to say that you can't put them on a future agenda and rehear them and do it right, and then they would not be null and void. But any actions taken in violation are null and void. And the Attorney General investigates. And the Attorney General can recommend penalties. And these are the penalties: $500 a day for a civil penalty. And it is a civil matter, it's not criminal. The officer can be removed. The officer in violation can be assessed with all costs awarded to a plaintiff. And the town cannot spend money for legal representation for the person accused of violating the open meeting law. Yes.
$500 per day. How do you count days? Isn't it just one instance?
It might be, or it might be if you're having serial meetings out there and you do it over and over and over again. Yeah. Good question, though. Any more questions about open meeting law? Because I'm done with that part. We're going to talk about conflict of interest now. Yes?
So if the body is not a decision-making body, they're advisory, or they just don't have power to really do any business, do they still come under the open meeting law?
Yes. And the reason why is because they do town business, they do make decisions. So, for example, the Planning and Zoning Commission makes a decision whether or not to recommend to council approval or denial, okay? Or whether to recommend approval with conditions, that kind of thing. So your decision is not a final decision but it is final in that you are making a recommendation.
So following that, I serve on two groups, and they're both separate 501c3s, the Industrial Commission and Chino CCEO. So they're separate 501c3 organizations. They don't necessarily influence anything the town does as far as taking actions. Are those incorporated in the public meeting?
I don't, off the top of my head, I don't know because I don't know how they're organized. If they're organized as subdivisions of the town, then yes. If they're organized as 501c3 totally separate from the town, Jamie's shaking her head no.
The Industrial Development Authority is a subdivision of the town. The other one that he mentioned is not.
Okay,
So
so
there is
there's your
a
answer.
difference there.
So what was the other one?
CCEO, Chino Community Enrichment Organization.
It's a
And that-
totally separate foundation.
Yeah, so that's not,
Yeah.
that's not.
I do have one question. In the meetings, when they have specific agenda items, is it a requirement of the board to allow the public to speak, or is that not a requirement?
Unless it's a public hearing, it's not a requirement. Yeah,
Because
Yeah.
I've seen it done both ways, and
Yeah.
so I wasn't sure.
yeah. And sometimes, usually, the public body will take comments from the public, but sometimes they won't. And it's up to the public body, unless it's a public hearing. So now, conflict of interest. How do you determine if you have a conflict of interest? Well, the first question is, do you have a pecuniary interest? And you say, what the hell is that? Well, a pecuniary interest is basically you stand to gain or lose something from the decision, something of value from the decision. So if the answer is no, I'm not going to get any business out of this, then you don't have a conflict. But you also have to look at, and this is where you can really get trapped, you have to look at your family members. So your family members include your spouse, your children, their spouses, I believe your brothers, sisters, mothers, fathers, their spouses. It's a lot of different people. We had a situation in Wickenburg where one of the council members' son-in-law had a financial interest in a real estate deal that came before the planning and zoning, came before the council for rezoning. The council member did not recuse himself because he had no idea that his son-in-law was involved. When he found out that his son-in-law was involved, he made that interest known, and the council had to rehear it with him recusing himself. So there's ways to fix it, and if it's inadvertent, then it's not such a big thing, but you don't want to do that. So if you have a pecuniary interest, you ask whether your interest is remote or substantial. So how do you know that? Well, if it's remote, we're going to talk about that on the next slide. If it's remote, you don't have a conflict. If it's substantial, you do have a conflict. And you need to, in the next, okay, we'll get there. What is a substantial interest? One that is not remote, of course. So then you ask, what is a remote interest? Well, there you go. So if you have a pecuniary interest, the best thing to do, there's a list in the handout of what all the remote interests are. But if you have a question, the best thing to do is call me. Call me, tell me what it is, and I'll be able to help you think it through. And oftentimes, members of public bodies will, in an abundance of caution, if they think they have a possible conflict of interest, they will go ahead and declare it, and even though they don't really have one. So, that's something to think about too. So what do you do if you have a substantial interest? Well, you cannot take part in the discussion or the action. You declare your interest in the public records. So you make it, you're sitting up there, you recuse yourself, you say, I have a conflict on this matter and I won't be participating. And you generally come down from the dais, or whatever your arrangement is. And then you fill out a form that Jamie has, or the clerk or whoever's taking minutes of your meeting will have. And that's it. Yes?
What if you're not sure, but you do announce that you could have possible conflict of interest?
Well, if you're going to announce it, then don't participate in the discussion and don't take part in the vote. Yeah. Yeah. But if you would rather not announce it, talk to me beforehand and then you'll know for sure.
Yeah, but if you have a conflict of interest and you don't announce it, but you weren't sure you did initially, later then you're...
Yeah, you're in trouble. So here's what happens. It's a civil suit to enforce the law, and the court may award reasonable attorney's fees. Again, the town can't pay for your defense, and it's a Class 6 felony for intentionally or knowingly, Class 1 misdemeanor for recklessly or negligently, and if the person is found guilty, they might be required to forfeit their public office. There was a state legislator, I'm not sure if he was a senator or what, or representative, but not too many years ago, he was required to forfeit his public office because he violated the open meeting law, or the conflict of interest statutes. And it was pretty egregious what he did. I can't remember what he did, but it was like, really? So, yeah.
And this may not be directed to you, but, all these folks are volunteers serving their town. Is there insurance that protects the town and those individuals in the eventuality something like that happens?
I don't know. There is legislative immunity and qualified immunity for some things, but I don't think so, not for open meeting law, or not for conflict of interest. Yeah, I don't think so.
I mean, it's criminal. I mean, to me, if you don't announce it, it's just plain dumb. But
I would agree. I would agree, especially since it's personal. It's not the town, Yes.
If you recuse yourself from a meeting only for a certain part of the discussion, can you participate after that discussion is over in the meeting?
Oh, yes, absolutely. If you recuse yourself from one item, you're only out for that item. Then you leave the dais for that item, and then you come right back. Yeah, you're not taking away the whole meeting, just that one item. Yes.
So you actually step away from your chair
Yeah,
and you go to another room, you go in the audience?
you can go in the audience,
Okay.
but you can't make faces at the council, at the members of the board. I mean, there are some communities where they make the person leave the room. But generally, no, that's not required. Okay, that's it for conflict of interest. Any questions? Any more questions? Okay, next is public records. And you say, why do I have to know about public records? Well, because some of the communications and the documents that you receive and that you will write in your job are public records. So what is a public record? Well, the courts, there's no definition in state law. It's kind of like the remote interest and substantial interest. There's no definition of substantial interest. So since there's no definition in state law, the courts have decided that there are three different definitions. So one is a record made by a public officer in pursuance of a duty for the purpose of disseminating information and memorializing official transactions. Okay. Another one is a record required by law or necessary in the discharge of a duty. And the third one is written record of transactions of a public officer in office, which is convenient and appropriate method of discharging duties, whether required by law or not. So, what's the takeaway from this? The general rule is public records must be produced promptly upon request. So that's why you have to determine whether your document is a public record. And each request must be reviewed to determine if the records are exempt from disclosure or in need of redaction. Sound complicated? I see some confused faces. Basically, if you're sending an email, because that's usually where it comes up, with the emails that members of public bodies send out. If you're sending out an email, you need to think whether it's a public record. And if it is, then you need to preserve it, or we're going to talk a little bit further about that. So, here we go. This is email. The rule is that emails received or sent by you are public records if they relate to your duties as a member of the public body, council, board, commission, or committee. In general, assume your emails on the matters coming before your body are public records, even if they're prepared on your personal computer. Now, this is something we like to caution you about because we recommend that you not put anything with town business on your personal computer. Because if there is a public records request, you're going to have to go through your personal computer, and maybe the town IT department is going to have to go through your personal computer to make sure that we've got all the records that are requested in that public records request. So it's a lot cleaner if you don't. Okay, so a document which is wholly personal is not a public record. So if you're emailing members of your public body and you're just talking about, let's go to dinner, that's not a public record. You can do that on your personal computer, no problem. Yes,
I have
sir?
a question. So I email the director, for instance, the planning director, say, here are some concerns I would like to discuss.
That's a
She
public
receives-
record.
She receives the email though, so that is already saved on her computer in the city. So
Yeah.
I'll go ahead and delete mine because it's already taken care of.
We would prefer you not delete it because it is technically a public record, even though she received it and it's a public record on her computer as well as yours. And until there's something in the law that addresses that, we still need to, if a public record request is made, we still need to produce it from you and from her. So here's our personal email accounts. Tips. Best practice, do not use your personal email for town business. If you do need to use your personal email, always send a copy to your town email address and or to the town clerk. And Jamie, do you have a preference on this?
We don't have a town email address for everyone, really just for the council.
Oop.
So this makes me think that maybe we should just set up a central mailbox. And so if in this case, Mr. Bacon wanted to send something to Ruth Mayday, he would also CC that central email box, and then we would just, it would be in our archive server.
Yeah, that would be a good
So,
idea.
yeah, I can talk
So
to
for
our
now,
IT about that.
CC Jamie.
Thanks.
And we'll fill up her email. Yes.
It's also a question for the IT staff, but most personal emails are web-based, not on the computer. So there's.
Oh,
a
that's
record
true.
of it. So it's not sitting on your personal computer necessarily.
That's true. Yeah, so that is a good question.
So the question I have, I've already deleted some of these emails. Oh, God. And they're not on my computer, but they're on the web service.
So if you can find those and send them to Jamie. Yeah, I mean, if they're gone, they're gone.
If I don't want this stuff on my personal computer, should I receive her emails?
Again, most people's emails are web-based, they're not really on their personal.
No, that's
computer.
true.
Business-based may be on a, if you have a personal
Oh.
business, it may be on an exchange server at the place of business, but most of them anymore are not on the computer.
That's true.
Will they take lots of that?
Okay, so when the town, I double-clicked here. When the town receives a request for public records that involves email, the town clerk will inform you if the request appears to include emails to or from you or your public body. If there are town emails in your personal email account, you will need to work with the town clerk and/or IT staff to determine how to properly search it and produce the records. And, you know, on the web-based ones, you can create a folder for all your town stuff. And if you did that, then that would make it really easy. So maybe the solution is not using your personal, but just making sure that everything that you send and receive for town business goes into that folder. And that would relieve a lot of headaches. So the question is, can I deny access to the records? We had somebody try to do this once. Is the record confidential by statute? And if it is, then the answer is probably yes. But there are not very many things that are confidential by statute. If it is confidential by statute, then the record can be withheld, but the party who requested it and didn't get it may appeal to the Superior Court to get it. And if the Superior Court reviews it and decides that it was not confidential by statute, then you get to pay their attorney's fees. On the other hand, if the court agrees with you, then they get to pay your attorney's fees. So this is one of the few times that happens. If the record is not confidential by statute, then there's what we do is called the Carlson balancing test. Are there strong reasons not to disclose? And have you consulted with the town attorney, which we always request that you do? Because the Carlson balancing test, basically, you look at whether the town's right to privacy or the person's right to privacy outweighs the public's interest and the public's right to know. So, you know, there aren't very many situations where the disclosure is not required. Yes?
Question just for procedure. We can't just call you willy-nilly. Do we not have to go through a process? Because I know, you know, we pay you for your services.
Right.
So if we have a question from the Planning and Zoning Commission that we need to have you address, do we need to get approval for that before we go spending money?
Yes. So generally, if it's a question about a public record, you would call Jamie.
Okay.
And Jamie would then either give you the answer, because Jamie really knows this stuff really well, or she would put you in touch with us.
Okay,
Okay?
thank you.
But we have more to this maze here. So if the answer is no to the Carlson balancing test, then the record must be disclosed. Any more questions? Yeah.
May I add to that, though, that we still, even if we do disclose certain records, there is certain confidential information that we
Right.
do not disclose your personal email address, home phone, things like that. So we do protect your personally identifying information.
Right, because there's also statutes on that require Yeah. That require the town to redact that information. And personal phone numbers also redacted. Oh, wait a minute, I went too far here. We're back on Code of Ethics. I double-clicked again, I guess. Okay, so here we are, Code of Ethics. So the town has a Code of Ethics. It was ordinance number 13768. It requires basically rules of good behavior. Respect for the public, civil and courteous conduct, speak and seek the truth, accept respectful dissension as a civic right. So when somebody's expressing an opinion contrary to your own, respect their right to have that opinion, even though you know they're wrong. Maintain professional conduct with staff. Observe mandates for conduct and process for complaints if necessary. So there's process for complaints set forth in the ordinance, and if you have an ethics complaint, it goes to the mayor or vice mayor if the mayor is involved. And then I was going to talk a little bit just about Chino Valley's form of government, because sometimes there's questions about this. And we have a council manager form of government where there's a clear delineation between policy and administration. This is common in Arizona cities, and sometimes the lines get a little blurred. So the elected council are the members who sit up here at the meetings, and they make policy decisions about the budget, taxes, town functions, that kind of thing, contracts. The council serves as a link between the citizens and government. And then the manager manages the day-to-day operations, takes care of the hiring, the firing, implementation of the policy directives from the council. And it's similar to the corporate structure of a board with a chairman and a CEO. So this is the statute regarding this kind of government. The city or town manager shall have and exercise powers and perform the duties relating to the affairs of the city or town as shall be specified by the ordinance creating the office of city or town manager. And that ordinance is part of your town code. So the town code has all the duties of the town manager. And one of the provisions of the Code of Ethics requires council members to deal with town employees solely through the town manager. And the reason I'm bringing this up is pretty much because, well, there's no council members here, and sometimes they get in trouble on this, but it's a good idea for board members too. You don't want to get into a position where a staff member feels like a commissioner or a committee member is telling the staff what to do. So why does this matter? And this is just a little graphic to show you that when you have a discussion with a staff member, you think that you're collaborating with the staff member. That's how you view it. But how the staff member sees it is that an elected official, an appointed member of a board or a commission is telling them what to do. Because there's a differential in the status, and they feel like you're their superior. So it's just better to remember that the council member or a member of a public body is one of 7, as was stated earlier, and does not act alone to direct the town business or the business of that body. Employees are always anxious to help. If you go to them and ask for information, they're always anxious to give it to you. But they're not likely to say no if you request that they do something. So please don't request that they do something. If you have a request of a staff member, please go through the town manager. because inquiries may be viewed as direction, but if it's generally just an inquiry, it will be taken as an inquiry, but just be careful. That's it. Any questions? Yes, Mayor.
Who are the three town positions that report to the council?
The town manager, town attorney, and town clerk. Oh, the magistrate.
Magistrate, these are the only people we can give directions.
Right.
But that says an
And the magistrate. Although the magistrate, because of the separation of
Very little.
powers, yeah,
Fire and
right, right, yes.
Sometimes in the planning and zoning meetings, we ask Ruth Mayday to bring us some information, or it's sort of it's more of a request, we never demand.
That's fine.
But there's some things we feel like we should know, and by asking her to bring those back to us, are those considered something more than an inquiry?
No, that's fine. That's fine. Any other questions? Okay, well, if you do have questions later, talk to Jamie, and if it's something Jamie can't answer, then she can contact me and I'll get you the information.
Thank you.
All right. Thank you all for coming.
Thank you, everybody.
company that we appreciate.
Now you're